Welcome to our comprehensive guide on statutory demands in Australia. Whether you're a creditor or a debtor, understanding the intricacies of statutory demands is crucial to protect your interests. In this video, we'll provide you with an overview of what statutory demands are, their purpose, and the necessary steps to handle them effectively. Statutory demands are formal written notices issued by creditors to debtors under the Corporations Act. They are powerful tools used to demand payment of a debt owed by a company. The purpose of a statutory demand is to provide a mechanism for creditors to enforce their rights and potentially initiate winding up proceedings against a debtor company. The first requirement is specifying the exact amount of the debt and clearly stating the nature of the debt owed. It's crucial to provide comprehensive details to avoid any ambiguity or potential challenges. Next, statutory demands must be properly addressed to the debtor company and served, usually at its registered office. It's essential to accurately identify the correct registered office address to ensure the demand is valid. Next, the demand must allow the debtor company 21 days from the date of service to either pay the debt, secure compound for the debt, or apply to set the statutory demand aside. Lastly, the statutory demand must be prepared using the correct form, as prescribed by Schedule 2 of the Corporation's regulations. Using the correct form ensures compliance with legal requirements and helps avoid potential challenges. In addition to the statutory demand itself, there are two important supporting documents that are required: an affidavit or a judgment. An affidavit is a written statement of facts sworn or affirmed under oath. It serves the purpose of providing supporting evidence and confirming the existence of the debt claimed in the demand. It's crucial to ensure that the affidavit is accurate, truthful, and supported by relevant documentation. In some cases, a creditor may have obtained a judgment from a court against the debtor prior to issuing the statutory demand. A judgment is a formal decision given by a court determining the rights and obligations of the parties involved. Now, let's shift our focus to how debtors should respond to statutory demands. Receiving a statutory demand can be a daunting experience, but it's important to respond promptly and take appropriate action to protect your interests. The first step is to seek professional legal advice from a qualified lawyer experienced in corporate and insolvency law. They can guide you through the process, assess the validity of the demand, and advise on the best course of action. Thoroughly review the statutory demand, paying close attention to the details provided. Check for any defects or inconsistencies that could potentially invalidate the demand. If there are genuine disputes regarding the debt claimed in the statutory demand, it's crucial to respond in writing to the creditor within the 21-day timeframe. Engaging in negotiations or disputing the debt can potentially resolve the matter without resorting to legal proceedings. If you are unable to pay the debt in full within the specified timeframe, it may be possible to negotiate with the creditor or enter into a repayment arrangement. Seeking professional advice can help you navigate these negotiations effectively. If you believe the statutory demand is defective, improperly served, genuinely disputed, or contains false or misleading information, you may apply to the court to set it aside. This legal process requires careful preparation and presentation of evidence supporting your case. To recap, navigating the complexities of statutory demands in Australia requires a clear understanding of the legal framework and procedural requirements. Seeking professional legal advice is essential to protect your rights and interests throughout the process. Thank you for watching. Don't forget to subscribe to our channel to stay up to date with our latest content. If you have any questions, leave them in the comments below.